Good afternoon. I call this meeting of the Michigan Public Service Commission to order on January 23rd at 11 a.m. And I'm not sure if I said good morning or good afternoon, but still is morning. And I ask Madam Secretary, please call the roll.
Chairman Talberg,
Present?
Commissioner Scripps,
Present.
Commissioner Phillips.
Present.
Madam Chairman, you have a quorum.
Thank you. All right, first up, is there a motion to approve the agenda?
Madam Chair, I move approval of today's agenda. Second.
All those in favor?
Aye.
Aye. The agenda is approved. Next up, approval of the minutes.
Madam Chair, I move approval of the minutes of the regular commission meeting of December 19th, 2019. Second.
All those in favor?
Aye.
Aye. The meeting minutes are approved. Item number 3, we have proposed amendment to our bylaws. We have Ryan Wilson here, our attorney, to describe the proposed changes.
Good morning, Commissioners.
Thanks.
The Michigan Public Service Commission adopted bylaws on January 22nd, 1979, 41 years ago yesterday. The bylaws were amended on April 1st, 2008, and there have been no amendments since that time. Following last year's appointment of Commissioner Scripps and Commissioner Phillips, the bylaws were reviewed for effectiveness and efficiency. As a result of the review, several changes were discussed and deemed appropriate for further consideration. Under Article 4 of the current bylaws, proposed amendments must be submitted in writing at a regular or organizational meeting and must lay on the table between that meeting and the next regular meeting, at which time such amendments must be voted upon. Before the Commission today are proposed amended bylaws which replace the existing bylaws if approved. Proposed bylaws before you make the following substantive changes. Article 1, Section 2, Office of the Commission. A provision has been added for satellite offices for staff members in order to effectively perform their duties. Article 3, Section 2 on meetings. Under paragraph A, within 60 days after the appointment of any new member to the Commission must conduct an organizational meeting. The current bylaws provide for 30 days after appointment. Under paragraph D, any revision to the regular meeting schedule may also be announced by posting to the Commission's website. Article 3, Section 6, Order and Conduct of Business. Under paragraph E, what has been the normal practice, the amendment explicitly adds a provision for a commissioner to make a verbal statement regarding the proposed action before voting occurs. Under paragraph G, there's been some modifications to the provision for public comments at commission meetings. Article 3, Section 7, Telephonic Participation. Video participation is added as a permissible means for a commissioner to participate at a public commission meeting. And Article 6 adds new provisions regarding non-discrimination. Finally, the amendment contains several minor edits and formatting changes for clarity and consistency. If the Commission approves a motion to submit the proposed amendment to the bylaws for consideration, a copy of the proposed amended bylaws will be attached to today's Commission meeting minutes.
Thank you.
Madam Chair, I move that the proposed amendments to the Commission's bylaws be submitted for consideration. Second.
All those in favor?
Aye.
Aye. The proposed bylaws are approved for consideration. Did I say that properly?
Yes.
Okay, the motion's approved. And thank you, Ryan, for your work, not only in ensuring that we're following our existing bylaws, but in identifying potential changes and areas where we could update them based on new technology capabilities and accessibility to the public. We appreciate your leadership.
You're welcome. Thank you.
All right. Next up, approval of orders on the consent agenda. And today the Commission is assisted by Lisa Gold and staff.
Good morning. Today's consent agenda consists of 2 communication matters, 6 electric matters, and 3 gas matters. The proposed orders for each of these matters have been thoroughly vetted by the Commission's technical and legal staff and are ready for your approval.
Madam Chair, I move approval of the orders and minute actions on today's consent agenda. Second.
All those in favor?
Aye.
Aye. The orders are approved.
Item 5A1 is case number U20623, which involves a notice filed by Talk America Services, LLC, of discontinuance of basic local exchange service and toll service. The order before you directs the Commission staff to post to the Commission's website a list of alternative providers with available comparable voice service, including reliable access to 911 and emergency services, in Talk America Services LLC's service territory.
Madam Chair, I move approval of the order in case U-20623.
Second.
And before we go to vote, I think Commissioner Phelps wanted to make a few remarks just to provide context on this order.
Just briefly, concerning the order in U-20623, the Commission recognizes that significant changes, technological changes, as well as business changes are taking place in the telecommunications industry. And though the Commission has previously approved the discontinuance of basic local exchange and toll services by providers, this is the first instance where a large number of customers would potentially be impacted and lose voice as well as reliable access to 911 and emergency services through this discontinuance. As a result, the Commission asked Talk America to delay that discontinuance of service while an investigation took place on the availability of comparable voice services by providers in their territory. I would like to thank our telecommunications as well as our customer assistance teams for their due diligence in addressing the customer complaints and comments related to this discontinuance, and for their work in conducting the necessary investigation of available service that was triggered by those complaints. Pending the passage of today's order, a list of alternative providers that offer comparable voice service and reliable access to 911 and emergency services will be available on our website. We encourage impacted customers to review that information online or contact the MPSC's customer assistance staff at 1-800-292-9555. But I just would like to add that, again, as this continual transition and change takes place in the telecommunications industry, it is certainly my hope, and I believe those of the other commissioners here, that we will continue to make sure that customers aren't left behind as a transition occurs between landline and other telecommunication services.
Thank you, and I would agree, and it's fundamental to our mission. Thank you for highlighting that
Thank
issue.
you.
All those in favor?
Aye.
Aye. The order is approved.
Item 5B1 is case numbers U-18361 et al., which involve the promulgation of rules establishing a code of conduct for utilities and alternative electric suppliers. The order before you closes certain dockets, opens a separate docket for each utility for the receipt of code of conduct filings, sets certain parameters for information sharing, and invites comment on 3 additional issues. Staff member Kirk Forbes is here to describe this order.
Good morning, Commissioners. I'm Kirk Forbes, manager of the Analytical Support Section in the Regulated Energy Division. The order before you closes certain dockets that are no longer pertinent or useful and opens separate dockets for each utility for the receipt of code of conduct filings. Further, it sets parameters for information sharing, proposes updated language to data privacy tariffs that conforms with the code of conduct, sets certain parameters for information sharing, and invites comments on 3 additional issues. The dockets closed in this order are outdated or no longer active. In the past, all utility code of conduct reports were filed to a single docket based on the type of report being filed. Assigning a separate docket to each utility for the receipt of code of conduct filings provides clarity for utilities as to which docket reports need to be filed, a permanent location for code of conduct reports, and an easy search for those trying to locate information reported by each utility. Utilities not currently offering value-added programs and services, or VAPs, now have a docket assigned should they entertain adding a VAPs in the future. If a utility shares information from its regulated business with its unregulated business affiliates, that information must be shared upon request with the competitors of its affiliates. The MPSC sought comments on 5 issues concerning the process of sharing this information in the September 26, 2019 order in case U-18361, including data security and privacy, timing of responses, same terms and conditions for sharing information, and establishment of competitor versus non-competitor for the purpose of receiving shared information. Based on comments received, the current statute, the code of conduct, and data privacy tariffs, the following direction is provided in this order. Sharing of customer lists, name and address only, does not require encryption or signing of a non-disclosure agreement or an NDA. Other categories of shared information beyond name and address must ensure written customer consent, making it clear to customers that information will be shared with affiliates and competitors. It should be noted that the Commission anticipates customer-initiated clearinghouse services such as Green Button Connect will eventually provide a solution to this type of customer consent. Next, based on outdated language since the passage of MCL 460.10EE, and to make tariffs conform to the Code of Conduct, the Commission is proposing that each current data privacy tariff be revised to include the following. Informed customer consent is not required for the disclosure of customer name and address to a provider of a value-added program or service, regardless of whether that provider is a utility affiliate or an other entity within the corporate structure or a third-party provider, in compliance with MCL 460, Section 10EE, 10A, and Michigan Administrative Code R 460, Section 101092. 5 business days meets the definition of contemporaneously under the Code of Conduct. The order makes it clear that identical information should be supplied to the competitor as was supplied to the affiliate or subsidiary. Next, competitors shall self-certify their status as a competitor and provide the utility with a description of their service territory when making a request for shared information. An information sharing request form will not be included on the MPSC webpage at this time. Lastly, the Commission will entertain comment on the following 3 issues. 1, free encryption products or services that would allow the safe transfer of customer-specific data at no cost to the competitor. They'll entertain comments on the proposed revision to data privacy tariffs of all affected utilities. And 3, commenters are invited to file simple NDAs for the Commission's consideration. These NDAs must avoid imposing unnecessary burdens on the competitors, including restrictions on using shared information in regulatory proceedings, and focus on reasonable protection of shared information.
Thank you. Thank you for your work working with others from our team to get the website set up and just help the Commission work through these issues. I think they're very complex, and at the end of the day, I think we struck the right balance between protecting customer information and ensuring a level playing field among competitors and utilities. Is there a motion?
Madam Chair, I move approval of the order in case U-18361 et al.
Second.
Did you have any further comment or?
I just would like to comment that, yes, there is this delicate balance that we have to play between ensuring customer privacy and data protection and facilitating competitiveness and innovation, which we know will help to facilitate many goals of the Commission and of the state, including some of the goals and priorities that we've outlined in the My Power Grid initiative. So I'm very much encouraged by the work of our team and our staff and the talent that we have here, and ensuring that we're kind of handling the tension between those 2 issues. And I'm also encouraged by the availability of services such as Green Button, which will allow customers to better access their energy information and be able to share that information with third parties.
All right. All those in favor?
Aye.
Aye. The order is approved. Thanks, Kirk.
Item 5B2 is case numbers U18349 et al., which is a matter on the Commission's own motion regarding the implementation of Section 61 of Public Act 342 of 2016. The order before you provides deadlines for the filing of Section 61 voluntary green pricing program proposals as well as for comments and reply comments regarding the voluntary green pricing program proposals, and orders a contested case in case number U20649.
Madam Chair, I move approval of the order in case U-18349 et al.
Second.
All those in favor?
Aye.
Aye. The order is approved.
Item 5B3 is case number U20359, which involves an application by Indiana Michigan Power Company for authority to increase its rates for the sale of electric energy and requesting other regulatory approvals. The order before you approves a settlement agreement that resolves all issues in the case. Staff member Ryan LaRue is here to describe this order.
Welcome.
Good morning, Chairman Talberg and Commissioners Scripps and Phillips. On June 24th, 2019, Indiana Michigan Power filed an application in Commission Docket U-20359 requesting, among other things, an increase in its retail electric rates of $58.5 million. Intervention in this case was granted to the Attorney
Ryan, do you want to move the mic a little closer?
Yes.
Yeah, just thanks.
Intervention in this case was granted to Attorney General Dana Nessel, the Association of Business Advocating Tariff Equity, Citizens Against Rate Excess, Energy Michigan, the Environmental Law and Policy Center, the Ecology Center, the Solar Energy Industries Association, Vote Solar, Sierra Club, the City of Auburn, Indiana, Great Lakes Renewable Energy Association, and the Residential Consumer Group. This case was subject to a full evidentiary hearing, including direct testimony, rebuttal, cross-examination, and legal briefing. Collectively, all parties to the case have negotiated and agreed to terms on all issues contained within the original filed application. These terms are outlined in the settlement agreement before you today. The settlement agreement before you agrees to a 2020 test year with a $36.4 million revenue increase relative to the rates approved in case number U-18370 in Commission Order issued April 27, 2018. This revenue increase represents a 38% reduction from the company's originally filed position and is calculated using an authorized rate of return of 9.86% with a common capital equity ratio of 46.56%. Other terms of the settlement agreement include the creation of plug-in electric vehicle pilots. I am plugged in. This pilot will include rebates up to $2,500 for workplace, multi-unit dwelling, and fleet incentives, and $20,000 incentives for interstate corridor direct current fast charging infrastructure. The settlement also outlines program timelines, budgets, and reporting requirements on the pilot program's progress to be submitted to the Commission. There is also the creation of a distribution generation tariff that will compensate DG customers for outflow based on I&M's power supply cost, including transmission. I&M also agrees to update depreciation rates for its metering infrastructure and accepts staff's guidance on future depreciation case filings regarding the company's generation assets. I&M agrees that it will not file another general rate application with the Commission until after January 1st, 2022. I&M agrees to drop its proposal to increase customer service charges for its residential tariffs, general service tariffs, and water and sewage tariffs as originally outlined in their application. If the settlement is approved by the Commission today, a residential customer taking service from I&M who uses 500 kilowatt hours of electricity a month will see an approximate increase in their bill of $12 or 15%. All signatories to this agreement agree that this settlement is in the public interest and request that the Commission issue an order accepting and approving this settlement. Thank you.
Thank you.
Madam Chair, I move approval of the order in case U-20359.
Second.
Before we go to vote, I just want to make a couple comments. The three of us were in Benton Harbor last year for the Integrated Resource Plan case for Indiana, Michigan, and the large majority of comments actually dealt with this case, their rate case, and concerns about proposed increases that would affect customers in Southwest Michigan. And I think the fact that the number of interveners and the variety of interests that were represented by the settlement that was unanimous is encouraging, and going through the full vetting of the hearing process to reach a resolution here. And at the end of the day, the settlement provides for additional necessary infrastructure investments as well as maintenance activities, and we encourage I&M to continue to focus on reliability. And this is kind of the blocking and tackling of the system, but to improve reliability from a standpoint of reducing both the frequency and number of outages in Southwest Michigan. So this rate case should help in that regard, and pleased to see it brought to closure. All right, with that, all those in favor?
Aye.
Aye.
Aye. The order is approved. Thanks, Ryan.
Item 5C1 is case number U20233, which involves an application filed by Consumers Energy Company for approval of the utilities gas cost recovery plan for the 12-month period of April 2019 through March 2020, an authorization of recovery factors for the same time period, and approval of a 5-year forecast. The order before you approves the plan and factors with amendments and accepts the 5-year forecast.
Madam Chair, I move approval of the order in case U-20233.
Second.
All those in favor?
Aye.
Aye. The order is approved.
Item 5C2 is case number U20569, which involves a matter on the Commission's own motion to require Consumers Energy Company to show cause why it should not be found in violation of the MISDIG, Underground Facility Damage Prevention and Safety Act. Staff member Eleanor Mundorf is here to describe this order.
Good morning, Commissioners. My name is Eleanor Mundorf, Acting Supervisor of Damage Prevention in the Gas Operations Section of the Energy Operations Division. On June 7th, 2019, the Commission opened this docket and directed Consumers Energy Company to show cause why it should not be found in violation of the MISDIG Underground Facility Damage Prevention and Safety Act, Public Act 174 of 2013. The Commission ordered the company to file a response by June 28, 2019, with direct testimony, exhibits, work papers, and affidavits supporting its response. On June 28, 2019, the company filed its response acknowledging its untimely responses to staking requests, which included supporting testimony, exhibits, and affidavit. On July 10, 2019, a pre-hearing conference was held before Administrative Law Judge Dennis W. Mack, with consumers, the staff, and the Michigan Department of Attorney participating in the proceeding. On December 10, 2019, the parties filed a settlement agreement resolving all issues in the case. The parties agree that consumers shall make the following payments. 1, a civil penalty in the amount of $1,045,000 paid to the Commission and used for underground facility safety, education, and training. 2, a direct payment in the amount of $100,000 to MISDIG Systems, Inc. for improvements to MISDIG. And 3, a donation in the amount of $300,000 to THAW, the Heat and Warmth Fund. The parties further agree that the approximately $1.7 million in costs incurred by consumers to eliminate the staking backlog experienced in April and May of 2019 and any costs related to facility damage incurred by the company due to staking noncompliance will not be recoverable from customers. The parties also agree that the settlement agreement shall resolve all matters related to staking noncompliance which occurred between April 1st, 2019 and July 1st, 2019.
Thank you. Before we go to motion, can you reread the civil penalty amount? I think you might have misstated it.
The civil penalty, $145,000.
Yeah. Yeah, thank you.
All right.
Madam Chair, I move approval of the order in case U-20569.
Second.
And on this, I just really appreciate the leadership of staff and how quickly, as the construction season picked up last year, we're on top of this to bring this about a resolution. I know the settlement kind of came later, but in terms of remedying the immediate issues that we were facing, and it's just critical for this system to work to keep activity in the state going forward, whether it's road work or other excavation activities, and for all the different players as part of the MISDIG system to be responsive and carry out their responsibilities. So again, thanks for your leadership in bringing about this resolution. All right, all those in favor?
Aye.
Aye, the order is approved. Thanks, Eleanor.
Item 5C3 is case number U20608, which involves the amendment of the rules governing the technical standards for gas service. The order before you approves the rules for submission to the Legislative Service Bureau and the Michigan Office of Administrative Hearings and Rules for their formal approvals. Staff member Kevin Spence is here to describe this order.
Good morning, Commissioners. My name is Kevin Spence, engineer in the Gas Operations Section of the Energy Operations Division and case coordinator for U20608. On October 17, 2019, the Commission opened this docket to amend the rules governing the technical standards for gas service. At that time, the Commission sought comments concerning the proposed revisions to the standards. On December 19, 2019, the Commission extended the comment period due, in part, to a jointly filed comment by Consumers Energy Company, DTE Energy Company, and Michigan Gas Utilities Corporation. In addition to the comments received during the initial comment period on December 4th and 5th of 2019, the Commission received comments from the Citizens Utility Board of Michigan on January 8, 2020, and supplemental comments from the Attorney General and the joint commenters on January 9, 2020. This order addresses the collective comments received. Notably, cybersecurity incidents are an emerging threat to the safety and reliability of gas service, and there are no current provisions, rules, or laws that address cybersecurity incidents for the gas distribution utilities in Michigan. The Commission finds that adopting a cybersecurity standard is necessary to address the emerging cybersecurity threats to Michigan's gas system. The API 1164 standard is an industry-specific security standard and is directly applicable to natural gas utilities. The Commission further finds that the benefit to customers is substantial and that the adoption of the API standard by reference is reasonable and appropriate. It is neither reasonable nor prudent to wait upon the approval of version 3 of the API standard. Nevertheless, a utility may file a waiver request as provided in subsection 5 of R 460.2302 to be evaluated by the Commission on a case-by-case basis once version 3 of the API standard is approved and prior to adoption by reference in a future revision to the technical standards for gas service. The order before you approves the technical standards for gas service as attached as Exhibit A and directs that they shall be submitted to the Legislative Service Bureau and the Michigan Office of Administrative Hearings and Rules for their formal approvals. Further, upon formal approval of the attached technical standards for gas service by the Legislative Service Bureau and the Michigan Office of Administrative Hearings and Rules, they shall be transmitted to the Joint Committee on Administrative Rules. Thank you.
Thank you.
Madam Chair, I move approval of the order in case U-20608.
Second.
Any comments on this? Okay, thank you. This is really an important issue dealing with cybersecurity, and I think the message here is that we're going to do everything within our power in order to protect critical infrastructure from cyber risks. And as the rules and other learnings enhance over time, we'll continue to update our regulations to keep pace. This is a great first step, and I appreciate your leadership, Kevin, and the rest of the team to bring this to this point at the rulemaking phase. All right, with that, all those in favor?
Aye.
Aye.
Aye, the order is approved. Thanks. Great. Next up, we have item number 6, public comment. Anyone seeking to address the commission should come forward at this time. No? Mr. Hazard? All right. All right. All right, we're delighted to see you in the new year. Item number 7, announcement of our 2020 regular commission meeting schedule. This is our first meeting of the year, and we always set the schedule for our commission meetings for the full year. Those will be available on our website later this afternoon. I also want to acknowledge she's actually over, I think, doing some auditing work on her last day. Katie Traxel in our renewable energy section is moving on for other opportunities, and wish her well. She was here at the outset with the renewable portfolio standard that was enacted in 2008 and has been instrumental in setting up the new voluntary green pricing programs in the state of Michigan. So wish her well and thank her for her accomplishments here. And then our next meeting is February 6th at 1:30 p.m. Are there any other announcements? No? Okay. All right. That concludes today's meeting. Is there a motion to adjourn?
So moved.
Second.
All those in favor?
Aye.
Aye. Meeting is adjourned.